States Court of Appeals for Veterans Claims is now in session. The Honorable Grant C. Jaquith presiding. All who have business before this court, draw near and you will be heard. God bless the United States and this court. Please be seated.
Good morning. I'm Judge Jaquith, and I'm joined by Judge Allen and Judge Falvey. We're convened today to consider arguments in the matter of Brian J. Held versus Dennis McDonough, Secretary of Veterans Affairs, case number 21-8048. Counsel for the parties, please enter your appearance for the record, beginning with the appellant's counsel.
Thank you, Your Honor. Dojaquez for appellant.
Thank you, Mr. Dojaquez.
James Drysdale for Appellant, Secretary of Veterans Affairs. With me is Jonathan Scruggs.
Thank you, Mr. Drysdale. Each party will have 30 minutes to present argument. Mr. Dojaquez, would you like to reserve a portion of your time for a rebuttal?
Yes, Your Honor, 7 minutes.
Okay, thank you. You may proceed.
Good morning. May it please the court, Kenneth Dojaquez representing appellant. On behalf of Mr. Held, I want to thank this court for the opportunity to present his appeal. With this appeal, Mr. Held asked this court to find that 38 CFR 14.636 C2II is invalid because it is inconsistent with the plain terms of 5904 C1 as interpreted by the Federal Circuit and MVA. 5904 C1 states that a fee may not be charged for services of agents with respect to services provided before the date on which a claimant is provided notice of an agency's initial decision under 5104 with respect to the case. Here, the agency's initial decision with respect to the case was issued in February 2017. Mr. Held prepared a motion seeking revision of that decision under 5109A on the basis of Q. The AOJ agreed, revised that decision, and provided notice in December 2019. Because that notice was issued after February 2019, the amended 5904C applies and entitles Mr. Held to a fee under that statute. It's important here that we understand that the case, as the term is used in the statute, has already been interpreted multiple times and covers this situation. Starting in Stanley, the Federal Circuit considered precisely this question in the context of the first iteration of that statute, where fees were not permitted before a final board decision on the case. There, the court held that the statutes allow attorneys' fees after the initial claims proceedings in connection with proceedings to reopen on the grounds of new and material evidence or clear and unmistakable error. Again, here, the initial decision was issued and a clear and unmistakable error was alleged. Later in Carpenter, the Federal Circuit expanded on this idea and emphasized that the Q is a procedural burden, not a case. The regulation seems to imply that a Q is its own case. But as Carpenter and later in Cameron in this court, the case is the issue that was presented to and decided by, and under this statute, the agency of original jurisdiction.
Could you, I just want to make sure I'm following that, because the statute also uses the term with respect to the case, initial decision with respect to the case. So leaving aside the regulation for a second, under the facts of Mr. Held's case, what is the initial decision with respect to, or what is the case, right? Because you have to be maintaining that the decision finding Q was the initial decision. What's the case then?
So the case, Your Honor, and that's really what this, the answer to that question will clear up all the ambiguity here.
Excellent.
So the case is the PTSD rating. That case include that the case of his rating includes both the rating, the effective date, and then any other issues that may be one of the 5 elements of service connection and with a claim. And in particular, I point this court to its own decision in Cameron, 26 Vet App 109. And there, the court said that the case under 5904 refers to a claim submitted by a claimant and adjudicated by the secretary, including the adjudication of all elements and theories in support of such claim, but does not include an additional claim for benefits that is presented after. There was a decision on a claim, and then the veteran or the veteran later submitted a request for a TDIU rating. And the court here in Cameron said that the TDIU rating was a separate case because although it could be part of that case, in that situation it was not because of the specific facts.
So, and I may just be slow on this, right? But it just strikes me that saying that it's about the PTSD rating is the case, right? Instead of clearing it up, it seems to me, at least for me, it creates more ambiguity, because then it sort of suggests that the initial decision on the case would have been the one that you're challenging based on Q. I guess what I'm wrestling with is, in the context of a Q issue, you by definition have an earlier decision that is final, right? And so you can't do anything about it other really than Q. I mean, you could have re-adjudication or something, but for our purposes, it's done. And so in the Q context, could the, quote, with respect to the case, refer to the actual filing of the Q motion? I mean, wouldn't that get you to the same place?
If I understand your question, Your Honor, you're asking, is the Q filing its own case?
Well, or couldn't it be? Isn't that a simpler way to do it? Think about it this way. All of the other decisions where we're talking about case, some of them might involve Q, but most of them aren't focusing on that, right? So here we have an earlier decision, which is on PTSD. And everybody agrees, I'm assuming you agree, right? Nobody appealed that, it became final, right?
Yes, Your Honor.
Okay, so that's final. We then have Mr. Held assisting in the filing of the motion to revise. Okay. In the context of the earlier decision being completely final, couldn't one think of the filing of the Q motion itself as the new case?
No, Your Honor. And
okay, well then, I am now more inclined to the Secretary's position than I was walking in the door. Because if we are saying that we want to go back to the initial filing, the PTSD, right, then we actually are saying that the initial decision in the case was at a time in which you needed to file the notice of disagreement first before you could get fees.
at that time, yes, Your Honor, but because the decision that was the more recent decision, finding Q and revising that decision, was issued after February 2019, the amended 5904C applies. And the reason for that is because, again, the initial decision, notice of that initial decision, or 5104, was provided already.
So which, and then I will let everybody else try. I just want to get this now. Then forget about with respect to the case. What is the initial decision here?
The February 2017 notice, Your Honor.
Okay, so you need us to then go all through that to say it's one continuous process from that time. That's the case, even if the case had already ended, that always is the case, right? And that will always be the initial decision.
Yes, Your Honor. That's the initial decision. That's what Carpenter says. That's what Stanley says. And that's what MVA, citing both of those cases, says. And Stanley in particular talks about, Stanley in particular talks about an attorney being entitled to a fee when, after a final board decision, the veteran either reopens with new and material evidence, which is now new and relevant, or clear and unmistakable error. And that was the holding in Carpenter, because in Carpenter, the veteran received a final decision from the board that granted a total rating, 100% rating. Then, within the time period allowed under the statute, he filed a motion to revise a 1979 decision, and which was 20 years prior to the board's decision. They found Q, they granted him additional benefits because it was a reduction issue similar to this one. They illegally reduced his rating, and the Federal Circuit said that the attorney is entitled to a fee for that Q, because the effective date is an element of the case that was decided, the rating case that was decided by the board. The situations in both of those cases are precisely the same. The case that was decided in 2017 was the rating, which includes all the various elements to include the effective date of that rating. And then the Q request to revise the prior decision is just another procedural mechanism for the case that was decided in 2017.
But neither Stanley nor Carpenter straddled the effective date of the AMA. Those were both pre-AMA board decisions, not even...
They were, Your Honor, but the same analysis applies, because important to understand here is that the decision that found Q was issued in December 2019. And under the public law, Section 2X, the amendments made in the law shall apply to all claims on which notice of the decision is provided by the Secretary on or after that date. And so because the decision finding Q and revising the prior decision was issued after February 2019, the amended statutes apply. And because the amended statutes apply, the analysis and interpretation from MVA tells us that all that is necessary is that notice was provided, an initial notice of an initial decision was provided, which occurred in 2017.
So AMA divides by decision, right? Not
Correct, Your Honor.
case, by decision. But isn't the problem that if the decision is the December 2019 decision, Mr. Held doesn't provide any representational services after December of 2019 for which he could be compensated?
The services, Your Honor, are those provided after the initial decision with respect to the case, which again occurred in 2017. So any work performed after 2017 on a claim for which notice is provided after February 2019 is eligible for a fee. And that's what 5104 says. That's what MVA says. MVA dealt with a supplemental claim.
5904, I think, right? 5104 is the decision.
Yes, Your Honor, 5904. MVA dealt with a supplemental claim, but it's the same analysis. The work performed after an initial decision that leads to another decision within the AMA, the amended statutes apply, and the agent here is entitled to a fee for his services. We point out, too, that, quoting here from MVA, on its face, the provision recites no other restrictions on attorney's fees, nor does the provision distinguish between work performed on different types of administrative review under the AMA, because all such work necessarily occurs after the AOJ issues an initial decision. A straightforward reading of 5904C1 indicates that work on all forms of review under the AMA should be compensable. And whether it's a supplemental claim for re-adjudication under 5108, or it's a request to revise a prior decision under 5109A on the basis of Q, it's still administrative work. still a review within the AMA because it occurred after the initial 2017 decision.
And so assuming we agree with you, what would you like the order to be? In other words, my question is, are there any facts to be found by the board?
No, Your Honor. All the facts that are necessary for a determination have already been determined. We know that the decision was issued in 2017, the initial decision. We know that the subsequent decision was issued after February 2019. And so and again, we point the court back to Carpenter, Stanley, and Cameron, in addition to the MVA, that the case here under the 5904C is the PTSD rating.
So, yes, so if you win on all of that, right?
Yes, Your Honor.
One of us, as I like to say, one of us has to write an opinion, right? And so is the opinion going to be that if we agree with you on the law, is it that, and the board has found the necessary fact-finding, therefore we reverse and order that Mr. Held be paid a precise amount of money? Are all of those sufficiently, in your view, in the record, or would there necessarily have to be a remand? Did you see what I'm asking? It's sort of ministerial. You've already won at this point.
Yes, Your Honor. I would have to go back through, but I do believe that the VA has already calculated the 20%. That is in the record. That should be, I don't know if it's in the ROP, but there was a fee determination made on page 771 to 774, and also 564 to 567. That should have calculated the 20%. So even though the board may or may not have specifically addressed that fact has not been disputed. And so the court could certainly order that either Mr. Held is entitled to a specific dollar amount fee or the 20% as per his contract with the veteran.
And can you remind me, what's happened to that 20%? Has it been withheld and just not paid to Mr. Held, or did it go to the veteran?
I cannot answer that question, Your Honor. I think the Secretary should be able to have that information. Typically what happens is the VA withholds the fee. Here, I think they did not withhold it, and they sent a letter to the veteran asking him to give it back until these proceedings were done. And then after the board makes its decision, my understanding is, and again, the Secretary can answer this better than I can, is that the funds are released to whomever the board decides get them. So I would suspect that the veteran now has the money, in which case it would have to be taken back again from them. But the Secretary should be able to answer that question better than I can. And the last point that I want to make is again citing to MVA and its reference to the House Report 115-135, that the purpose of the new law, the AMA, was to expedite appeals while protecting veterans' due process rights. And it's accomplished by allowing veterans to retain services of attorneys and accredited agents who charge a fee when the AOJ provides notice of the original decision. Because an accredited agent will, in virtually every case, help to protect, as well as attorneys, the veterans' due process rights at every stage. And so we have to keep in mind the purpose of the law and the purpose of the amendments of 5904 were to get accredited folks involved at the earliest opportunity. And this court and most of us practitioners have struggled immensely with how to do queues. They're very complicated. Even understanding what is a queue, a pro se veteran would benefit greatly. The protection of his due process rights would benefit greatly as the purpose of the statute and the amendment to the statutes provides.
But this is a transitional problem, right? The transition from the legacy system to the AMA system and the concern with representational activities straddling that system. But how does MVA apply the new version of 5904C retroactively to adjudication and representation that occurred under the old 5904C?
It does not, Your Honor. The short answer, to begin, MVA was a rule challenge, and so there wasn't a case before it that had applied the law. It was a rule challenge where the Federal Circuit held that the limitation, very similar to this limitation on a supplemental claim, was invalid under the plain terms of 5904C1. And in that case, the invalidated regulation, which by the way is still on the books, required that there be an initial, two types of supplemental claims, one that was filed continuously under 5110, or one that was filed more than a year later. And the invalidated regulation required a decision on the supplemental claim before the agent or
They
attorney
really
could charge.
only invalidated that portion of the regulation.
Correct, Your Honor. But we're citing to MVA for its interpretation of the statute, which informs us as to the invalidity of this regulation, which essentially imposes the same requirement, that there has to be a decision within the AMA on the Q, or in MVA, the supplemental claim filed more than a year after. In both cases, the statute is clear, Congress's intent is clear, MVA is clear that once the initial decision occurs, then all work performed, even if that decision was in the 60s, in the 50s, in the 90s, whenever it happened, as long as there has been initial decision and another decision within the AMA, the attorney or agent is entitled to a fee for his or her services.
But doesn't the regulation 14636C capture the change of 5904C that was wrought by the AMA, so that it provides agents can charge claimants for representation provided after the agency has issued notice of decision on a claim, if the notice was issued on or after the effective date of the AMA, or if the notice was issued before the effective date of the AMA, then an NOD, a notice of disagreement, has to have been filed. Isn't that what the statutes say too?
That is not what the statutes say, Your Honor. And again, MVA says that on its face, the provision recites no other restrictions on attorney's fees, nor does it distinguish between work performed on different types of administrative review. All work performed on all forms of review under the AMA, including the 5104CB supplemental claims, should be compensable. So the statute does not require that a pre-AMA decision have been responded to with a notice of disagreement before an agent or attorney is entitled to a fee. It's any work performed after the initial decision is eligible for a fee. And that portion is, and again, we ask for you to invalidate, this court to invalidate the regulation. Really, it's just that one portion that requires the notice of disagreement with respect to a pre-AMA or a legacy decision.
But MVA doesn't speak to the effective date of the AMA.
It does not, Your Honor.
So I think that's Judge Jaquith's point, is that there's an effective date where this becomes effective on or after, and you're asking us to basically apply the statute retroactively to those work done after an initial decision before that effective date that are then resolved by a decision after the AMA effective date, right?
Yes, Your Honor.
So that's the problem, is you got two decisions. The use of the word decision, maybe even the worse of the use of the word initial decision in the regulation in both cases, in both aspects. So we have initial decision meaning two different things, right? You have
Yes,
the
Your
initial
Honor.
decision in 2017 on the rating or the effect, the rating, and then the initial decision on the Q after in December of 2019.
Well, and I want to look at the regulation to make sure that,
Because, for example, CFR 3.2400, the modernized review system applies to all claims, requests for reopening of finally adjudicated claims, and requests for revision based on Q for which VA issues notice of an initial decision on or after the effective date of the AMA.
So,
Excuse me for 1 second. You're
Yes, Your Honor.
beyond the end of your time, but would you add 3 minutes?
so that regulation, Your Honor, I don't believe is implicated here. If it is, then we would ask that any mention of an initial decision on a queue is likewise invalid because it conflicts with the public law itself. The public law, again, going back to Section 2X, says, "The amendments made by this section shall apply to all claims for which notice of a decision under 5104 is provided by the Secretary on or after the February 2019 date." It doesn't say the initial decision. And I recognize that 34.3. That the regulation does use the term initial decision, which injects additional confusion into the matter, but that is a separate initial decision, so to speak, from what we see in 5904. 5904 is the initial decision with respect to the case, which again occurred in 2017. And because a decision, notice of a decision under 5104 was provided after February 2019 with respect to this case, the amendments of 5904 apply.
Got it. Thank you.
So we're not.
But to be compensable, don't the representational services have to have been provided after the decision?
After the initial decision, Your Honor?
After the decision that's within the ambit of the statute that applies. And in this case, that's a statute that says the filing of an NOD has to be the predicate.
No, Your Honor, because there were no benefits, well, there was no representation in 2017 when that decision was made. If Mr. Held had represented him, the veteran, in his 2016 claim, and those benefits were awarded, then he would not be entitled to a fee for that decision. But again, MVA is very clear and completely encompasses the situation that this question is asking. If the work is performed before any work performed between the initial decision and the decision that is issued after February 2019 is compensable, whether it's a supplemental claim, as MVA dealt with, or whether it's Q, as this case asked the court to consider. The triggering, the important things, the important dates are the date of the initial decision and when is the next decision issued that is a result of the services that were performed.
Okay. Thank you, Mr. Dojaquez.
Thank you, Your Honor.
Mr. Drysdale?
May it please the court. The facts of the case are uncontested. The regional office issued a rating decision in February 2017 that granted a temporary total rating and stated that the prior 50% rating for PTSD would be reinstated after expiration of the total temporary rating. There was no notice of disagreement filed with the February 2017 rating decision. The board's application of the law to the facts is also uncontested. Appellant's brief concedes that the applicable regulation prohibits payment of fees in this case. So we're left with a pure question of law. And appellant's argument has been limited to challenging the validity of the regulation as inconsistent with the statute. But the second...
So, Mr. Drysdale, you agree that the key statutory language is initial decision with respect to the case, right?
Yes, Your Honor. And we agree with the appellant's position that the initial decision in a case here would be the February 2017 rating decision, because under Carpenter, under Stanley, the case includes any subsequent work done to challenge that initial decision based on the basis of clear and unmistakable error.
So what I'm wondering though is then from your perspective, the reason that fees could be, so let's just assume that the decision that was being challenged with respect to Q had occurred after the effective date of the AMA. And the same thing happened here, which is the request for Q is granted, or the motion is granted. The Secretary's regulation draws a distinction between those two types of events, right?
It does.
When the first decision. And if you were to point to the part of the statute that allows you to draw that distinction, keeping in mind that the Federal Circuit in the supplemental claim context has seemed to suggest that drawing the distinction between a continuously pursued supplemental claim and one that isn't supported by statutory language. What would you point us to in this case that would allow us to say, and dear Federal Circuit, don't reverse us because what you said in MVA doesn't apply here? You follow what I'm saying?
Yes, absolutely, Your Honor. So the statutory language that the Secretary relies on and would point the court to is Section 2X of the public law, the applicability section. So it's the effective date of the amendment to 5904 as set forth by Congress. So that date is February 19th, 2019. And
but how does that though, and maybe the answer is the Federal Circuit didn't consider this at all.
Right.
But at the time the Federal Circuit was considering the amendments or the regulation, right? It did that in a direct challenge under the APA, of course, so it didn't have facts in front of it. But it was doing it at a time that essentially anything that wasn't a continuously pursued claim by definition had to have occurred in the legacy system. I mean, just by the dates, I think.
Right, and well,
do you see what I mean? Because well, the court didn't expressly talk about crossing over the threshold between one system and another, right? That was the context in which, just by the calendar, it was going to exist.
Right. I do understand that. And so in MVA, the Federal Circuit was looking only at the amended version of the regulation. And so that obviously had the effective date. But it really was not considering at all, such as the facts here, an initial decision that occurred prior to the effective date of the changes made in the AMA legislation to 5904. So a legacy decision that is the challenged decision that is challenged on the basis of Q. So the challenged decision was a legacy decision, and this is a legacy decision.
So what would the Secretary's position be if somebody today, so we have a legacy decision that is final. Let's just assume that. Legacy decision that is final. It is more than 1 year from the time of that decision, and a person files a supplemental claim with respect. Can that person get fees because would the VA take the position that, well, even though the Federal Circuit said that you can't distinguish between types of supplemental claims, here the initial decision on the claim was in the legacy system and it was more than 1 year later and therefore you can't do it?
Well, I think the distinction there would be that a supplemental claim would not be the way to pursue revision based on clear and unmistakable error.
No. Assume but assume that they didn't, right? Assume the person said, I'm not saying the initial decision had clear and unmistakable error. I'm filing a supplemental claim and I'm going to submit new and relevant evidence. And they do. Right? And the benefit is fully granted.
Right.
But the person had not filed an NOD under the legacy system, right? It's a new lawyer.
Right.
Would VA say under that, even with MVA, the Federal Circuit's decision on MVA, that fees would be inappropriate
No, Your Honor, I don't believe so. I believe fees would be appropriate there because that's not really asking for revision based on Q or clear and unmistakable error, which is what we have here.
Yeah,
And
but
so
why does that make a difference? The only difference in those two situations essentially is the size of the check, right? Because in a claim for re-adjudication in a supplemental claim, the effective date, assuming it's not continuously pursued, right? The effective date would be the date of filing of the supplemental claim. If instead you said the initial decision that it had Q, the only difference would be then the effective date, the amount of money would go back to the initial filing, right?
Right, I believe that's correct, yes.
So why does that make a difference about whether a fee would be appropriate? The size of the check?
Well, because I think, to take a step back on this a little bit, Congress has updated the statute several times and moved the fee triggering event several different times. And in each of those cases, an effective date for the change has been provided by Congress, and that's been challenged, in prior implementations, and it was held not to be retroactive. So I think the reason it would make a difference is because that's Congress's considered judgment on the matter. They've provided an effective date from which the new amendments in the regulation would take effect. And so anything that happened before that is still governed by the prior version of the regulation. That was litigated in Cameron, affirmed by the Federal Circuit, in the context of the change that happened in, 2006, 2007. That was not a retroactive repeal of the prior version of the statute. And the prior version of the statute applied to decisions that were issued when that version of the statute was in effect. So because
But the effective date, you just made a crucial point, but the effective date applies only to the statute, right? The Congress doesn't set the effective dates for the regulation. They're not involved in the regulatory process at all.
Well, that's right. That's right, Your Honor. And so, the Secretary sees no daylight between, the regulation as implemented and the statute. And so if you look at the regulation, it's structured in the text and structure of it, you have C1, C2, and C3. The C3 really relates to the earliest version of 5904 and explains if a case is governed by that version of the statute, these are the rules that apply. C2 tracks with the version of 5904 that was in effect from 2006 to 2019, which the initial decision here we say would be in that. So that says if the statute governs that these are the rules that apply. And C1 tracks with the amendments made in the AMA legislation as of 2019 and says, okay, if you have an initial decision that's governed by this version of the statute, these are the rules that apply. So Congress didn't spell all of that out in the AMA legislation itself, but it does provide effective dates for the AMA legislation. And so VA wrote that into the regulation because we're still working with 3 active versions. We have cases that are governed by 3 different versions of the statute. Prior to 2006 to 2019, and then 2019 to present. So C1, C2, C3 track the requirements for each of those different statutory structures. So the whole statutory scheme really has to be, considered when deciding whether, a case falls within, is governed by this version of the regulation, the first, the second, or the third iteration. And Congress did provide specific effective dates for those. And when the 2006 change was made, it was litigated, and similar arguments were made that it was a retroactive appeal, that the newer version of the regulation should apply, to cases before 2006, and that was rejected by this court, and this court's decision was affirmed by the Federal Circuit. So I think for the court to take a different position, in this case would be really a sea change, and quite different than, what has been done by this court and the Federal Circuit in the past. And really, the regulation, the statute were likely, drafted in this way because it had been sort of had the judicial imprimatur that it was permissible.
Is there a principled basis besides the brightness of line drawing for continuing to apply the NOD requirement rather than the slightly more beneficial to veterans notice of the agency decision requirement?
Well, I mean, Congress has made that judgment. It's a policy decision. And I would say Congress does have an interest in protecting veterans from, improper diminution of their fees by, or of their benefits by excessive legal fees. So, Congress has moved the fee.
Does it protect veterans by making it less likely that they're going to have representational services as they try to navigate the complexities of this system, especially involving Q and the transition from legacy to AMA?
Well, there are competing interests. I do acknowledge that. But Congress has sort of expressed its judgment on the policy of those. So, in the initial stages, and we'll take the facts of this specific case. So the initial rating decision in 2017 just made a factual error. It said you had previously been granted a 50% rating. Well, the veteran had been granted a 70% rating prior. So it was just a very obvious, clear, unmistakable error. There's no doubt about that. As soon as that was brought to VA's attention, it was corrected. And so the question, the policy judgment is really, should a veteran have to pay thousands of dollars?
Was it? I mean, that doesn't really bear out factually, does it? I mean, it was brought to the agency's attention in September of 2018 at the latest, and they didn't do anything about it until December of 2019.
Well, the decision was issued in response to the first notice that VA was put on notice that there was an error. So, had the veteran raised it, at any point, once it was raised, it was corrected without the need for complex legal maneuvering, argument, anything of that nature. So, if the veteran had said, hey, I previously had a 70% rating, he said I had a 50, I don't think that's right. It's, once that was done, it was corrected.
Yeah, but,
So
but doesn't the fact that if this was so obvious an error, I can't remember the veteran's name right now, the veteran didn't have the ability practically to contest the initial decision, right? I mean, he didn't see it as such an obvious error. It was only when he had representation that this was brought forward.
Well, I don't know if there's anything in the record to support the veteran's state of mind. I mean, he could have filed, he had the legal right to file an
Well, he
NOD.
did, but what you're saying is, to Judge Jaquith, is, hey, we don't have to worry about veterans not getting help on these motions, because just look at this one. It's so clear it was 50 and 70. I agree, except it couldn't have been that clear, because it would strike me somebody would have then said at the time, within the 1-year appeal period, hey, I should have 70, not 50.
Well, I mean, I do take the point, but, I would just say that, the veteran is the one receiving the monthly check. If he noticed it had decreased, VA could have reasonably expected him to say, hey, I don't think this is right. And, once that finally happened, it was corrected without any need for, legal proceedings.
Didn't he do that? I don't think we have the document in the record, but the board references a communication from the veteran in either 2017 or early 2018. I think 2017.
Right.
Challenging the reduction.
Yes, there was
the reduction that occurs here, it sounds like it's a Scrivener's error, but there's some sense in the record that what they actually did was measure in a back room somewhere his symptoms, his PTSD symptoms against the rating criteria and say, this seems more like 50 to us. And just ignored the fact that he had a pre-existing 70% rating, and there was a due process requirement to give notice and an opportunity to be heard before they reduced his award. So this wasn't just a slip of a pencil.
Well, we don't have that information in the record before us, and I don't actually know, what precipitated the error. There's no question there was an error, that he was entitled to 70%. It was a clear and unmistakable error, and once it was raised, that was corrected. So,
But to Judge Allen's point, this is the kind of egregious error of law that cries out for competent representation for veterans to help them spot the error and seek to have it corrected.
Well, I think it was an error of fact, not so much an error of law that requires legal acumen to argue. If you get a check and you say, this check is, substantially less than it used to be, what's going on here, that doesn't require a high degree of legal competence that you should then be required to go and pay an attorney to, do that.
But
so,
didn't he respond at that level? Didn't he respond at that level? What's going on here? But he didn't say, wait a minute, I've been denied due process. You've reduced my rating without so much as a proceeding.
Yeah, and I think the whole, conversation here really started with why would Congress make this decision? And, that has been well fleshed out in the body of law that's developed over decades, that Congress wanted VA to have an opportunity, have veterans to come to an agency with a non-adversarial posture to get decisions on their claims. And then if that was not favorable, then bring in paid counsel. So, circling back, that is a judgment that Congress had made. And they've changed that judgment a bit over time, continuing to push that fee triggering event earlier, but it doesn't diminish the fact that that is what Congress intended, and that is how it has been effectuated over time, and that's discussed in the body of law in this court and the Federal Circuit. I don't think that's a controversial, proposition, that the initial interactions between VA and the veteran are to be non-adversarial, and the veteran should be able to get the most amount of their benefits possible. But then if it's not going that way, then they can bring in paid counsel.
Right, that's the time period for them to collaborate as partners in an effort to provide every benefit to which the veteran's entitled before a paid agent, a hired gun, if you will, steps in and calls out or creates conflict, right? But that didn't work here. Well,
I mean, as soon as the veteran raised the issue to VA acknowledged that it was a clear, obvious error and corrected it. So, I mean, in that way, it did work. Now, the fact that he didn't do it through a notice of disagreement after the initial decision and waited more than a year and then filed that as a motion to revise based on clear and unmistakable error, that's, just factually the situation that was here. That was the remedy he had available at that point. But he certainly could have raised a notice. It filed a notice of disagreement. So
what's the impact of the veteran's claim in October of 2019?
The claim for, sorry.
Well, that's a good question. The claim for ? Because it's not in the actual claim itself is not in the record of proceedings. But what we do have in the record of proceedings is a decision, an internal decision form addressing only Q, not the other disability claimed increases, and it lists the date of claim as October 15th, 2019, and the date of the decision finding Q as December 2019. So we see that, but we don't see what the October 2019 claim is other than VA connected the two. And in fact, the rating decision that we're talking about here as the post-AMA initial decision begins, you filed a new claim and an increased claim for benefits that was received on October 15th, 2019, and based on review of the evidence, we've made the following decisions, including restoring your PTSD rating to 70%.
Well, Your Honor, I don't have that in front of me, so I don't know. I'm happy to follow up if it's of interest. I can say that the motion for revision of the 2017 decision based on clear and unmistakable error was filed in September 2018, and the RO issued a decision on that in December 2019.
As I understand the position, and following up on Judge Jaquith's question, none of that would matter to you, right, as the Secretary's counsel, because what you would say is, tethering yourself to the language of the statute, as I understand it, is the statute says initial decision with respect to the claim. You agree that, oh, case, and you agree that the case is the PTSD case. And you agree that the initial decision with respect to the case is from the 2017 decision. Am I with you so far?
Yes, yes, Your Honor.
Okay, and then what you say is, and this is not meant to be, casting an aspersion. This is how I'm understanding your argument, so you can correct me if I'm wrong. To say that language, initial decision with respect to a case, even though the parties agree the case is PTSD and the initial decision is 2017, we can say that what Congress meant was because the AMA becomes effective under this 2X, right, which we dealt with in Maddox and then the Federal Circuit did as well, we should read that when Congress meant initial decision with respect to the case, it was pulling in all of the prior way in which attorney and agent fees were dealt with.
Well, yes, Your Honor. So the Secretary would say that the plain language of the statute, including the applicability provision at 2X, does result in that reading. That's the way the Secretary reads it. We believe that's the plain reading and the plain meaning of the statute. And then, as a follow-on or alternative to that, I mean, if there is any ambiguity about whether that old type of interpretation should come over, I think that deference under Chevron would be appropriate because the Secretary did specifically address this situation where the claim straddles the legacy and the AMA systems in the Federal Register. So 84 Federal Register at 149, it says, that a request for revision of a prior decision based on clear and unmistakable error in filed. Well, I'm sorry, I'm not going to read the language, but it does address this specific situation. It says when you have a legacy decision, and that is the decision that's challenged on the basis of Q, then the and then you have but that's done after the 2019, that you're going to get a new decision, AMA decision on it, but the statute governs because the prior version of the statute governs, the pre-amended version governs. So it's set out and discusses this specific situation where you're challenging a legacy decision on Q after implementation of the AMA.
What if somebody were to say, well, then why didn't Congress say after initial decision in the case, comma, other than with respect to a motion to revise the initial decision based on clear and unmistakable error? If Congress had used those words, we would be at the same place that your argument is now, but we wouldn't have to be doing that, right?
Right. Well, I mean, Congress does say so the amended version of the statute applies to where there's an initial decision on or after February 19th, 2019. And that's not the case here. I think the parties agree, at least, that the initial decision was in 2017. So that really should be the end of the matter, in our view. And I think...
Well, isn't the December 2019 decisions is an initial decision? The question is whether it's an operative one.
Well, it's not. So with respect to the case being the correction of a rating or the rating for PTSD from 50 to 70. So that initial decision was there. The initial decision that was issued in 2019 was about, clear and unmistakable error in the initial decision.
Let's assume that the December 2019 decision had denied the motion to revise based on Q, okay? And then Mr. Held files a whole bunch of other things, does a higher level review, which then continues the denial of the Q motion. He files a claim to the board denies the Q motion, right? He comes to the court remands, the board again denies, he comes to the court, it goes back, and then eventually an adult comes into the room and says, we made a mistake, it was 50, it should have been 70. And so 8 years later, it's resolved. No fees.
I mean, I believe that would be correct under the reading of the law and when the work has to be performed and the version of the statute that governs the initial decision based
So
on
that's
the
what I mean.
challenge.
So with respect to any claim that straddles the AMA legacy divide,
Right.
the Secretary's position is Congress has essentially said you can never get a fee because the December 2019 decision here is like a stateless person, meaning it is not an initial decision with respect to a case because it's nothing, right?
Well, only if there had not been an NOD filed.
How often
on
does
or
it
after.
happen that there's a Q motion preceded by an NOD, right? The Q motions are designed to address a decision that's become final because there wasn't an NOD.
Right, and I don't have.
They categorically
statistics, but-
exclude?
No, Your Honor, because there are plenty of cases in the legacy system where an NOD would be filed, and then, a supplemental case statement of, a statement of the case would have been issued, but then no VA Form 9 or, it wasn't completed. The appeal was not perfected. So there can be plenty of situations where an NOD was filed and then the claim or the case just kind of, stopped at that point. It wasn't prosecuted or pursued any further. And in those
So
situations.
how would you describe the December 19 decision here? Because it strikes me it's not an initial decision on anything, right? Because if it's an initial decision, then the person would get fees if the RO said, no, there's no revision. So if it's not an initial decision under the AMA, it's not a supplemental decision. I mean, what is it?
Well, like in this type of case, it's a decision correcting, adjudicating a motion for revision based on Q. It's not an initial decision on PTSD rating.
But it can't be an initial, it's not an initial decision with respect to a case.
Right. Well, that's right. It's part of that case because Q is part of the PTSD rating. Filing a motion to revise the initial decision based on clear and unmistakable error is part of that same case.
So
and
then other than altruism, why would a lawyer or agent ever assist a veteran in a Q case claim with respect to a decision that predated December 19, 2019?
with no NOD. Where no
With
NOD.
right, that's what
Yeah.
we're talking about. If
Yeah.
there had been an NOD,
So
it wouldn't be.
I can't answer that, but that was the the statutory structure in those cases that govern those cases for, from 2006 to 2019. And so,
Well,
allowing
except that all of the old cases, right? We're getting this a lot from both sides because we're dealing with situations where people are talking about law that was made when there was only a single system. And now we have this bizarre world in which we have two systems that simultaneously exist. And depending on the day, one side or the other says that law that pre-existed it governs, or that law that pre-existed it is totally irrelevant.
And I
right?
see
And
my
so,
time has expired, but I do have a response if I'm permitted.
Please give Mr. Drysdale 3 minutes.
So, Your Honor, I think those type of concerns show, this case and the decision in this case, I think would be very analogous to the situation that was at issue in Maddox, 34 Vet App 61. We're talking about the notice requirements under the AMA and whether that applied retroactively to cases. And so I think the decision could look a lot like that decision, the reasoning, the rationale. It said that this concurrent system of legacy and AMA, this complicated situation is, quote, the centerpiece of Congress's design. So, that is what Congress did. So, the confusion, the difficulty, the complexity, it's not a flaw in the system, it's what was intended. It was intended to change the system prospectively, create this new system under which new rules apply Whereas, prior, you're governed under these old rules and the way it had always been. And those versions of the statute still apply. And that's how the regulation.
But
in this
Maddox
case is-
involved whether significant new requirements applied. In this case, we're talking about a change that reflects a new reality, but with a very similar threshold, right? I mean, the difference is because of the different options available under the AMA system that don't involve an NOD. So
Right.
the NOD is no longer a viable threshold.
Right, and Congress
So the
made
next
that
best
change.
thing is the AOJ decision notice, which in the normal course of things would be right up next to the NOD, right?
Right, and Congress did change that fee triggering event, but then they put an effective date on the changes to the regulation and when that event would become effective. So that's what the regulation attempts to effectuate. We see no daylight between what the various versions of the statute require and the regulation as it's written, and the structure of the regulation tracks those. So, we think the plain meaning and the plain language control, but otherwise that, VA's regulation is a permissible interpretation. And one final point in my final seconds, and not to really shift gears too hard, but I would just draw the court's attention to the record at 2854. So that is the fee agreement between the veteran and the representative. They contemplated this in the text of the agreement. They said that the representation would be for work on appeals where an NOD was filed on or after June 9th, 2007. That's not done here. So to Judge Allen's question to my friend here, what should the decision look like? Are there any factual findings? I think, if the court were to agree completely with appellant on the law, that additional proceedings would need to be remanded to just discuss the scope of that representation agreement. So,
Thank you, Mr. Drysdale.
thank you, Your Honors.
Mr. Dojaquez, rebuttal argument?
Thank you, Your Honor. I want to start with where the Secretary and the appellant surprisingly agree. The Secretary agrees that the initial decision.
While it's fresh, why don't you start with the impact of the March 2018 fee agreement here?
And as part of that, why now, because I had not thought of this point this way, why would this not make this an advisory opinion? In other words, the fee agreement that your client entered into, let's assume you're right on the law, actually limited fees more than what the law would have allowed him to get, because it included a requirement that was for an NOD to have been filed, and there was never an amended fee agreement that removed that requirement as a matter of contract between them. And so why would it not be an advisory opinion to issue the decision that you're asking for?
Several responses to that, Your Honor. Number one, this court has repeatedly held that late arguments are not proper. And the Secretary has never raised an issue with the content of the fee agreement, not before the AOJ, not before the board, not before this court. And in a backhanded comment at the end of his extended time, he raises some issue with the content of the fee agreement. So,
But wouldn't we always, if we've adopted the case in controversy requirement, and part of that would be advisory opinions, I think that if memory serves me, I think the court issued an en banc decision yesterday.
Did, Your Honor?
That that basically said it's our independent obligation to always consider whether or not we have jurisdiction.
Second response, Your Honor, is that whether the fee agreement, what the fee agreement says are factual determinations, which this court is precluded from making in the first instance under 7261C, Tadlock, and so on. And so even if there was a question about what the fee agreement called for, that's something for the board to determine in the first instance, which can then be appealed to this court. And incidentally, it would be something that the AOJ would have to do in the first instance under 7104A's one review on appeal provision. And so the court would essentially be leapfrogging two different reviews, violating both the veteran and Mr. Held's rights to due process and an opportunity to actually be notified that there was a problem. Third response is that in Chenery, the Supreme Court emphatically held and has subsequently reaffirmed that the courts cannot affirm a decision on a basis that was not relied upon by the agency.
No, but I would actually be, looking at this differently to follow on the Secretary's logic. If I were writing it based on his view, I wouldn't write that it's an affirmance. I would write that it's a dismissal, because we have the authority to find facts for our own jurisdiction. We have to. And if in fact we determine that there wasn't a controversy because of the fee agreement, I mean, it's an interesting issue, because it would be a dismissal, because we would no longer be issuing a decision that was, now that might not work, I don't know, but it's just, this is an intriguing argument that I agree with you. As I've said to you in different contexts, Mr. Dojaquez, right, I don't like late raised arguments either. And the one exception is in the context of jurisdiction, when it goes to the court's power to act at all.
Right, Your Honor. But, and I would urge the court that that kind of a question is really something that Congress left to the agency to determine in the first instance. And that's the heart of Chenery, is that the courts don't tread upon the territory of the agency. If there's a problem with the content of the fee agreement, then we would urge that that's something for the agency to determine after the court decides whether the regulation that was applied is valid as it interprets the plain language of the statute.
While we're on unaddressed items, what's your position on the October 2019
Yes, Your
claim
Honor.
and whether Mr. Held participated in that?
And yes, Your Honor, that the Secretary's stance here was that it's such an obvious thing that all somebody had to do was say, hey, you guys messed up. But that's not what happened. And Judge Jaquith, as you pointed out, this is from the board's decision, record at 6 and 7, August 2017, the veteran stated that his rating for PTSD was improperly reduced. The September correspondence, the VA responded to that and said, we're not going to do anything for you unless you file a notice of disagreement or submit new evidence, which is completely contrary to the Secretary's position here, that all you had to do was tell us that it was improperly reduced. Point of fact, it was not a factual error that resulted in the revision of the decision. The December 2019 decision, as per the board's decision, reinstated the 70% because the veteran was not afforded due process. As I explained in my opening argument, the entire purpose of the amended version of this statute was, the fee statute, was to get attorneys and agents involved to protect the due process rights of the claimants. This was a clear violation of due process that was raised to the VA, ignored by the VA, and it wasn't until the proper procedural mechanism was used, using the words clear and unmistakable error, citing to the statute 5109A, that the VA finally, after more than 15 months, took notice of it and said, oh, okay, now we're going to look at it and we'll correct the mistake. And it was the work of the agent that made this happen, not the simple raising of the issue to the VA. I only have a few more seconds, but I did want to talk about the effective...
Excuse
yes,
me,
Your Honor.
since we took the early part of Mr. Dojaquez's time, please give him an extra minute.
So the effective date, going back to the concessions by the Secretary, the parties agree the initial decision with respect to the case was 2017, as per 5904C. The parties also agree that the case is the PTSD rating. So the question the outstanding question, which we don't think is whether the AMA rules apply, the amended 5904 applies. And the answer is yes. And the Secretary talks about this, the effective date of the amended statutes. But going back to Section 2X, it says the amendments shall apply to all claims for which notice is provided after February 2019. If you look at the prior amendments to the fee statutes, going back to the Veterans Benefits Health Care Act, Public Law 109-461, we can see that the effective date provision, and that's when when Congress shifted the fee trigger to the notice of disagreement from the final board decision. This is the effective date. Amendments made by this law shall take effect on a date that is 180 days after the enactment and shall apply for services that are provided with respect to cases in which notices of disagreement are filed on or after that date. So they're comparing apples and oranges. In the prior amendment, the effective date of the statute was put on hold for 180 days. So there was 6 months where these amendments did not apply. It also only applies to cases when a notice of disagreement was filed after the effective date of the statute. We don't see that in Section 2X of Public Law 11555. All it says is that these amended statutes apply when notice is provided after February 2019. All of the elements have been met under the statute. The Secretary's regulation imposing this requirement of a notice of disagreement is invalid because it's contrary to the plain language of the statute. Deference should not be afforded because his interpretation is unreasonable, creating a system where an agent or attorney can never earn a fee for any legacy decision on the basis of Q in which a notice of disagreement was not filed is contrary to common sense, is unreasonable, and contrary to the plain language of the statute. And we'd ask that the court find that provision invalid and grant relief to Mr. Held.
Thank you, Mr. Dojaquez. Judge Allen, Judge Falvey, do you have any more questions? The court thanks both parties for their arguments. The case is submitted for consideration and the court is adjourned.
All rise. Court is in recess.